I want to say thank you again to all of the competitors and the coaches, and of course our wonderful judges for making this weekend such a huge success. We've gotten nothing but incredible feedback on everybody's performance, and you should all feel very, very proud. And I especially want to thank the judges and the coaches because I know how much work you put into this, and it's all volunteer time, and we so appreciate it. So let's please give them a big I also want to thank, again, Liberty Mulcahy for all of her, and Chris Hayek, wherever he is, there he is, for all of his assistance. And of course, Lindsay Kadish, thank you so much. Thank you again to Northwestern University School of Law. It's been just a wonderful experience here, beautiful facilities, and everybody made things so easy for us. And I would love to bring Professor Kristen Stilt down here to just say a few words. And thank you, Professor Stilt, once again for all of your support and for helping to make this a reality.
Thank you. And I said this last night at the reception, but just for those of you who might not have been there, on behalf of Dean Dan Rodriguez, who's not here this weekend, we welcome you to Northwestern. We hope you had a wonderful time. We're very honored and pleased to have been able to hold the competitions here and feel like it's a testament to our investment and dedication to animal law, and we're very pleased that you were able to come. And many of you probably didn't know that behind the scenes working with Liberty and Lindsay was, from our side, Jody Ingerson, a fantastic assistant here at the law school who worked tirelessly for many, many hours, and we just wanted to give you a small token of our appreciation.
Yes, thank you, Jody. You made everything so easy for all of us. We so appreciate it. And so now it is time for the awards. And let me just describe what the process is going to be. As you know, there are 3 different elements. We're going to have judges from each of the elements say a few words about their experience and their impressions of the competitors. And then I will announce the various certificates and plaques. When you hear your name, please come down and accept your certificate or plaque and stay here for a few moments and we'll take a photo. And then we'll move on to the next one. And we're going to start with the legislative drafting and lobbying competition, and Judge Chris Green judge the final round. And if you can join us, that would be wonderful.
Hi, it was a really cool experience. First time I'd done it, I had to learn it on the fly. We had some judges sort of have other issues that caused them to leave pretty quick. So yeah, it's pretty funny doing the whole Frank underdog thing. I was really trying. It took me about a good 20 minutes to get back out of character. Our next thing, I kept having to resist the temptation to like look directly into the camera and give these little sidebars, like, look what he's doing now. But yeah, just the quality of everyone was fantastic. It was really, really, really difficult. I think also in the closing argument as well, like the level of competition was so high. I did this the very first year. They did the competition, I did the closing argument, and yeah, and judged it for like 3 or 4 years afterwards, and it just, in the past 5 years, the level of competition has increased incredibly. So yeah, congratulations to you all, and just for taking the time to do this, it's really cool.
You'll just stay here so that we can take photos with you, and so I'm going to start with the best bill and fact sheet, and I am pleased to report that that certificate goes to competitor number 18, Meg York of Lewis and Clark Law School.
Not to slip back into the accent.
And then, as you know, there were 4 finalists, and so now I'm going to announce the 2 finalists who will receive certificates, and after that I will tell you who received second place and then first place. So the two finalists, the first one is competitor number 21, Sarah Dudley from Golden Gate University School of Law. Sarah had to catch a plane, so she's not here, but we'll be sure she gets her certificate. And competitor number 18, Meg York with Lewis and Clark Law School. All right, and in second place, receiving a plaque, is competitor number 26, Callie Shapiro, the John Marshall Law School. And of course, that means that in first place in winning this competition is competitor number 27, Toy Hutchinson, also from the John Marshall Law School.
I would have done whatever you asked. Really? I was like, I want this, like, okay, sure. Thank you. Congratulations.
And now we're going to turn our attention to the closing argument competition. And I'll ask that judges Josh Marquis and Diane Balkin please join us down here, and Chris Green again, to give a few remarks.
And we're going to have Gavin come on down.
And Gavin, yes.
My name is Josh Marquis, and I've been with the Animal Legal Defense Fund, I think, for, 17 years since Pam first got me involved. And I just want to say I hire a lot of young prosecutors, and all of the contestants, to say nothing of the finalists, did at least as well as what I consider a second or third year deputy in my office. So I want to really commend everybody. You really did great. Thank you.
I'm Diane Balkin. I'm with the Criminal Justice Program of ALDF. I want to first thank Laura Dunn for writing the problem and being our timekeeper. The competitors were unbelievable. It was a particularly difficult decision for us, and I would echo what Josh said, that the quality was impeccable, they were professional, and they caught nuances that the judges even missed. So everyone did a fabulous job. Thank you for your commitment and for having us here.
So again, there were 4 finalists, and I will first read the names of the 2 who are receiving certificates, and then again, second place and first place. So receiving a certificate is competitor number 15, Gerald Tan from the John Marshall Law School. And also receiving a certificate is competitor number 33, Vicky Otero from Northwestern University School of Law.
It's funny finally hearing where people actually went to school, too.
And in second place, receiving a plaque, is competitor number 14, Nicholas Navarro from the John Marshall Law School.
Have charisma and like the drinking fountains that John
Yeah, exactly. And in first place in winning this competition is Meg York, competitor number 18 from Lewis and Clark Law School. Congratulations to all the competitors. So now we turn our attention to the Appellate Moot Court Competition. And first, I will announce the award for Best Brief and Best Oral Advocate, as well as the semifinal certificates. And then Judges Smith, Pearson, and Tischler would like to address the finalists with a few remarks, followed by Judge Smith announcing the winner of the final round. Does that sound like a good plan? Okay.
I follow your lead.
Okay. So first I'd like to start with Best Brief. And Best Brief goes to team number 20, Stephanie Wilson and Anna Bennett from the University of California, Irvine School of Law. We also have the award for Best Oral Advocate, and this is based just on the preliminary rounds. And before I say who this winner is, I would just like to say that in the preliminary rounds, everybody sees 6 judges, and this person won Best Oral Advocate of all 6 rounds from all 6 judges and received perfect scores across the board from 2 of those judges. So this person dominated, and that person is Anna Bennett. And then we did have 2 teams that were in the semifinals that we would like to honor and acknowledge with certificates, and they are team number 14, Gregorio Silva and Robert Teas. Are they here? Yes. Please come back. And team number 17, Kirsten Sneed and Megan Miller from Michigan State University College of Law. Are they here? We are hiding. We both wore purple yesterday. And now I would like to turn things over to our panel of judges, and I believe Judge Smith may be starting with the comments.
Thank you very much, Dean Fresh. First of all, this is the 4th or 5th time that I have had the opportunity to judge this competition. Actually, there were a few other times I was invited and planned to come, but given the February dates, weather has a way of intervening sometimes, and I didn't make those events. But it's always been a great pleasure. It's such a well-organized competition with such a fascinating focus. It's a very, very unique moot court competition, and you can take that from somebody who this December will have been a judge for 30 years, right now 25 plus on the federal courts. So I've seen and participated in a lot of moot court competitions, and this one is absolutely superb. And that is because of the folks who organize it and administer it year after year. I feel I've made friends here in the years that I've been participating. Pam and Liberty, they both put up with the fact that I send them an annual Humane Society calendar that features, among other folks, my dog. So, yeah. But anyway, I thought because this is an appellate competition and because I'm an appellate judge, a judge on the Court of Appeals for the Third Circuit, I just take a few minutes to provide some counsel, if you will, on appellate advocacy, actually and briefly, both written and oral. This panel did not see the written submissions. We didn't see the briefs, heard only the oral arguments. But I read a lot of briefs. In fact, truth be known, that when often I encounter someone I have just met and they ask me, what do you do? I reply, I read bad writing for a living. Sadly, it's true. The well-written brief is a rare commodity, and it certainly behooves anyone in law school and beyond who intends to do any kind of advocacy in court, but especially in the courts of appeals, to hone their writing skills. You would be amazed, maybe not, to discover the extent to which people overwrite. And we, Court of Appeals judges, especially note that because we read so much. Less is usually more. I have come to thoroughly detest most reply briefs, for example, because rather than be in the form of rebuttal, which is what they're supposed to be, taking on, responding to issues raised in a responsive brief that hadn't been initially set out, they end up being nothing but a rehash of the argument initially made, which is not what they're supposed to be, and a waste of everybody's time and effort. Short, declarative sentences, well-framed issues, and not too many of them. I have a colleague, a very, very senior colleague, Judge Aldisert, who has written extensively and has published numerous editions of his book, Winning on Appeal, which some use as a textbook in appellate advocacy courses, in which he says that he is immediately suspicious when he opens a brief and sees someone setting out 10 issues. I mean, come on. You know, there weren't that many errors made. Pick your shots, decide what your strong suit is, what your strong issue is, and write accordingly. I read a brief this morning after I got up. I am an early riser, and about the first thing I do after taking the dog out and having my first cup of coffee is to pick up a brief. That's the exciting part of being the Court of Appeals judge. And there was a statement of issues. And the statement of issues listed about 8 or 10, but they didn't match up as you read the body of the brief with the issues that are set out throughout this 60-page brief. We notice those things, needless to say. Less is more. Write clearly. Do not write repetitively. And pick your issues based on how salient they seem, not simply because a client may want you to set out a particular issue because he or she thinks it's important. And that often obtains on the criminal side of things, especially on the defense side. Okay, oral argument, which you have exhaustively participated in, I must say. I'm amazed, and which is why I don't want to talk too long because you're going to collapse, I think, as much as you've been doing in recent days. But bear in mind that when you are before many appellate courts, and I can say this is true of the courts of appeals, you're not there many times for any reason other than the fact that judges want to hear about issues they want to hear about. Now, in the Second Circuit, they hear oral argument on every case. This is the court of learned hand, a court of great traditions. I think all of the courts of appeals throughout the country are courts of great traditions, but that happens to be one of theirs. In most courts, in my court, the Third Circuit, we select the cases for oral argument. Of those cases that we receive, we determine oral argument will be helpful here. Maybe we spot a reversal, probable reversal. We want argument in that kind of case. Maybe we really want help on an issue. We want oral argument. Maybe it's a case that involves a special public interest so that we ought to have argument out there in the open. But if you get oral argument on your case, bear in mind you have a limited amount of time, just as you did here, 15 minutes. You want to tell the judges what they want to hear about, not what you want to say. And you're squandering your opportunity if you're not then responsive to the questions that have been asked of you in oral argument. I have heard responses to questions, well, Judge, that's not this case, in response to a hypothetical. Well, I know that's not this case. That's why I used a hypothetical in the question. You don't want to respond to questions that way. An extreme example that I've used from time to time was a situation involving a friend of mine who'd gotten into a case late in the game because an attorney friend of his asked him to handle this case on appeal. My friend was not an appellate lawyer largely. He was a trial lawyer, a prosecutor. He'd gone out into private practice. And he took on this case for his friend, and it turned out, quite frankly, to be, and not because I want to get in competition with Anna here, but I'll use a pun. The case was a dog. And my friend got beaten up pretty well in oral argument to the point where he looked up to the presiding judge, our former chief judge, and a very low-key and soft-spoken man by the name of Anthony Sirica, and he said, Judge Sirica, could I ask a question here? And I think Tony was a bit taken aback, but he said, yes. And my friend said, could I be doing any worse here? That is not an approach that I recommend. You answer questions, you don't ask them. Be as responsive as you possibly can, and then return to the message you have. Don't read it. I mean, we don't simply regurgitate what's in the brief. We've read the briefs. I mean, most courts of appeals, most federal courts of appeals, I can assure you the Third Circuit, we have hot benches. We're asking a lot of questions. We've asked you there because we want those questions answered. So focus on that and use those opportunities accordingly. So with that said, that very, very small primer on oral advocacy, I provide you and then turn you over to the tender mercies of my colleagues here on the bench to make comments as well about the performances of all four advocates, all four of which were excellent. Naturally, I will be announcing the winner in a few moments. After the comments, I can assure you it was a tight race.
Thank you, Chief. I am pleased to have been invited back to participate this year. And while I don't know that I have the deep history that Judge Brooks has, indeed, it's been a pleasure each time I've been back. And this might even be my second time being a judge in the finalist rounds. So I'm especially grateful for this opportunity. You were absolutely fantastic. And trust me, we don't say that just to make you feel good. you have some idea of that, otherwise you wouldn't have been one of the two teams appearing today, but it's indeed representative of the truth. I loved it that you were all poised, confident, looking us in the eye. I think it's important to remark generally that when a question can be answered yes or no with some follow-up, I'd suggest you do that. Some of you did it better than others, but it goes back to what Judge Brooks was saying about give the judges what they want. And by and large, you did for the most part, but after one of us had you circle back. But you all did a really good job, and I'll comment, Ms. Wilson, you were the first to have the opportunity to circle back to something, and I think you even used my name in getting back, which certainly caused me to look up from my notes to say she remembered the question and is indeed getting back to it. And judges like that, because one of the things, and the true appellate judge here can tell you later if you ask, is that after we hear oral argument, there's a caucus, there's a conference. And one of those judges would be able to say, didn't you hear the answer to my question? Therefore, please agree with me on that point. I really liked the answer you gave, Mr. Brooks, to this question. It took a long time in coming, but when pushed, you gave it, and I can't imagine a better articulation. And the question was something like, why shouldn't Mars Hope and Samuelson be allowed to intervene? And you simply said because they're the same as each other resident of Hobbs County, and they're all being adequately represented by the department. That got you an extra point from me for sure, and from my colleagues as well, because I know you did quite well from all of us. So that was very, very good and well handled, I believed. I really admired, Ms. Lang, your command of the case law. Time and time again. You gave a case, you gave the citation. I didn't see you read it. You weren't reading them, were you? Well, I couldn't tell.
Candor is always appreciated from me.
It was conversationally done. I mean, I wasn't off-put by you looking down, so it appeared that you had, I won't even reduce it to rote memory, but you just simply knew what those cases were and when to pull them forward. And I saved Ms. Bennett for last. It was a joy. It was a pleasure. It was indeed one of the finest arguments I've had the benefit of hearing. The only constructive criticism I offer is that you could have used more case law, but I won't trick you into thinking that your argument lacked because you hadn't, but in a different case, different circumstances, maybe you keep that in mind. But indeed, it was a joy, and all of you excelled today, and thank you for allowing me to weigh in.
Before I turn to Judge Tischler, just a couple other comments, and the comment relative to a command of case law made me recall that I had not said this. In addition to the case law, and we certainly at the appellate level want advocates to have a command of the authority that they have mustered and/or that is controlling or even just persuasive for our purposes. Know the record. Always know the record. And if you don't know a question about the record or anything else, there is no shame in saying, I don't know, or I'll get you that when I sit down, or, may I submit, a supplemental to the court. There's no shame in that. In fact, the judges appreciate the candor of being told, I'm not going to bluff my way through this question. I don't know that right now, but I can get you the answer. Judge Tischler.
Thank you. I'm the only person here who's not a real judge, and so I do thank the both of you for your graciousness in letting me tag along. And I know that that you folks have been through round after round of comments, so I don't have terribly much to add to what was said, other than you'll probably notice that my questions tended to be pretty simple and tended to be asking you to treat me as a human being, just answer my question. And as a former litigator, I know how one can be put on the spot and be thinking, oh, Lord, I know if I answer this directly, I'm going to lose. And so you're wrangling and trying to get back to script. But ultimately, answering the question directly is the right thing to do. Give the judge what the answer that he or she is honestly asking you for. And that's all I have to say.
And all very true and very helpful. There, some of the most enthusiastic expressions of approbation that I've heard from colleagues over the years following oral arguments have been after counsel has made a concession, which is to say, not that you throw in the towel, but on an issue that really doesn't matter in terms of the ultimate outcome, don't argue it uselessly and wastefully. Don't charge up San Juan Hill on something that's weak. You will enhance your credibility with that quorum by conceding the issue and quickly moving to the next point. That sincerity will be appreciated. So will be my shutting up and announcing the winner of the competition. And the performances of all four of you in oral argument was exactly as my colleagues have described them. You were all very good, very, very good. I can speak only for my own scoring paper, not looking to my colleagues or over their shoulders. But in my own calculations, there were only 2 points difference between the two teams as I graded them. But judges are in both the real world and the moot court world charged to make decisions, and make this one we must. And as between the two teams, the panel has determined the winner of the final round to be Team 20.
Can we please have Team 15 from Lewis and Clark Law School please come down and receive your we can have all of the judges. We're going to do just one group picture with the judges and the competitors who. I don't know if we're going to be able to seal it. There's going to be a lot of us, but that's okay. We can do it.
There we go. So.
And with that, the 11th Annual National Animal Law Competitions comes to a close. Thank you again to everybody. All the competitors did a wonderful job. Thank you to our volunteers, our wonderful timekeepers, and of course to our judges and coaches. And safe travels home wherever you're heading. And we'll see you next year. Thank you.